Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Video number 2034. In this video, we are going to discuss Section 12 of the Domestic Violence Act 2005. Honorable Gauhati High Court, in the case of Noor Muhammad Ali versus Rashida begum in CRLMP number 905 by 2022 on 12/9/2022 held that it is not mandatory to get the domestic incident report from the protection officer in case the magistrate wants to continue or wants to give a decision on the request of the so-called victim. First of all, let us know the importance of Section 12. So, Section 12 of the Domestic Violence Act 2005, it says that the magistrate can act on any application filed by the victim or the presiding officer regarding any of the reliefs like right to shelter, right to compensation, all these things. And in this connection, it is mentioned in the Act that the magistrate shall take into consideration of the protection officer's report. So that is to say that if the officer's report is there, yes, definitely they can take it to consideration. But it is not mandatory that they have to obtain the domestic incident report from the protection officer. This point is clarified in this particular case. Right. So, Section 12 does not mandate it for the magistrate to consider the domestic incident report from the protection officer or the service provider before passing any order under the Domestic Violence Act. And please remember, it is clarified that even in the absence of the domestic incident report, the magistrate is empowered to pass both ex parte or interim as well as the final orders on the Domestic Violence Act. Interim order, yes, for some time till the matter is decided, she can be asked to be compensated with some amount. And ex parte decree, if the other party is not present, definitely they can pass the ex parte decree. So likewise, they can give the final orders also, right? Actually, this is based on the very recent Supreme Court judgment, Prabha Tyagi versus Kamlesh Devi, 2022. Please remember, this relates to Criminal Appeal number 511 by 2022, decided on 12th May 2022 by two judges bench, Madam Nagaratna and M.R. Shah. In this case, of course, if you go to the details of the case, the marriage was solemnized on 18/6/2005 between Kamla Devi and Prabha Tyagi. Right? It was held in Haridwar district, I believe. Right? Actually, they have given the dowry, they have given the stridhan. As per the Hindu marriage traditions, they have performed all these things. But after 1 month, even not, I think 28 days or so, on 15/7/2005, almost 1 month, 15/7/2005, the husband, that is Tyagi, died in a road accident. By that time itself, she consummated. She became pregnant. Ultimately, on 30/3/2006, she gave birth to a daughter. Husband is no more. Now, the in-laws, that is the in-laws of the so-called Kamla Devi, they threatened her not to interfere in the property of her husband, number one. Number two, not to enter the house of her husband. So she cannot reside in the house because immediately after the marriage, so she was responsible for the death of her husband. Of course, what she can do? When the accident takes place, what is the accident which is not expected? He died in the accident, that in a motorcycle accident. What is that she can do? But they have borne grudge against her and they did not allow her. This led to the domestic violence. Right? So now, please remember, she was asked not to enter the house of the so-called husband. So therefore, they approached the domestic or magistrate and applied for the section 17, that is right to reside in one of the portions of the husband, right? So actually here the domestic incident report was not received, but the magistrate clearly held that yes, she can claim relief. So as per section 12, it is not mandatory to consider the domestic incident report. Therefore, the magistrate has given temporary shelter order to her. Likewise, please remember, so normally we are under the impression that the magistrate should consider this domestic incident report. Sometimes it is not at all necessary. So very good judgment in favor of the prosecution, in favor of the women. If at all you come across such cases, definitely you can mention this case. So two cases we have discussed, important. Number one, Prabha Tyagi versus Kamlesh Devi 2022, that is Supreme Court case, and Gauti High Court case. This is Noor Muhammad Ali versus Rashida begum. So you can cite both these cases, right? Okay, thank you very much.